Hello everyone, this is Lahama Mazumdar, Assistant Professor, School of Law and Justice, Adamas University, Kolkata. Today in this lecture I will be speaking about doctrine of graphical representation under the law of trademarks. So the doctrine of graphical representation essentially entails that a trademark should be capable of being represented graphically in order to be registered under the Indian trademark law. So once you refer to the Indian Trademark Act of 1999, which defines trademark, you will be able to see that a mark is registrable. A trademark is a mark that is capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and this may include shape of the goods, packaging, or combination of color. So to qualify as a trademark, a mark should be represented graphically. A mark has to be distinctive and also has to be represented graphically. So if you want to answer the question that whether a olfactory mark, a smell mark, a sound mark, or a color mark qualifies as a trademark, the answer could be if it can be represented graphically, if it can distinguish goods and services of one trader from that of the other, then it could be registered as a trademark. But the problem is that can you graphically represent an olfactory or a smell mark? Can you graphically represent a sound mark or a color mark? There lies the problem. As you can see in the slide in front of you, graphical representation essentially entails that the visual representation of the mark acts as the connector or the source identifier that links the good bearing the mark to the public. Graphical representation is the capability of a mark being put in a register in physical form and also being published in a journal. In Swizzle Maclow's limited application, right, in this particular company's application, the trademark application was refused registration on the ground of missing graphical representation. The court explained the two chief reasons for the requirement of graphical representation. The court stated that graphical representation enabled the traders to identify with clarity with other traders what other traders have applied for registration as a trademark and for which product. So essentially, when you are as an individual entity or a particular company applying for registration, until and unless the other company graphically represents its trademark in front of you, you'll not be able to understand whether you still have the chance of registration or not. So that is why requirement of graphical representation is important, because it enables the trader to identify with clarity what the other trader has applied for and why you cannot apply for it. The graphical representation of a trademark also enables the public to determine with precision the signs which form the trademark registration, right? In the sense that when the consumer altogether looks for a trademark, the graphical representation of the trademark essentially helps them identify the trademark. So that is one of the reasons why graphical representation is a very important criteria. Now, referring to a document which essentially speaks of the relevance of graphical representation, right? As you can see here, This, this article essentially speaks of the criteria of graphical representation under the Indian law, right? This article is written by Atish Chakraborty, whereby he has explained graphical representation and the Indian trademark law. So, on referring to this particular article, uh, we've already seen that when we look into the trademark, a trademark is requiring two particular criteria. It has to be distinctive and it has to have graphical representation. Right? So, essentially, when we speak of graphical representation, right, we also looked at Susan Matlow's uh, application, right? Why it was denied, right? Because it couldn't enable, like it, the traders could not understand what mark was being applied for, right? So this is one of the grounds why graphical representation is required, right? So under the Trademark Rules 2017, which superseded the old Trademark Rule 2002, graphical representation is defined therein as representation of a trademark for goods or services represented or capable of being represented in paper form, and has been expanded to include representations in a digitized form as well, right? So graphical representation therefore becomes a very important factor in determining the subject of registration. In under section 2 clause 1 clause ZB of the Act, it suggests that any representation of a trademark has to be done, a graphical representation has to be done, so that it could be reducible to a paper format in accordance with the form prescribed for registration. Now the problem with regard to graphical representation as a criteria comes up for marks which are non-conventional in nature. For word mark or for any label, for any sort of mark which can be graphically represented, it is not an issue. But the issue arises with regard to marks which are non-conventional, right? Because non-conventional marks like smell marks or sound marks, it is not very easy for them to be graphically represented. The reason for this being that non-conventional mark, these marks are protected, like it's only in certain jurisdictions where graphical representation is not included. So there are certain kind of mark like shape of good, the motion marks, the mark, color combination, smell mark or sound mark, which create the problem with regard to them being non-conventional marks, where they are facing the issue of not being able to be represented graphically. And to some extent that is why these kind of marks face a significant challenge of registration, as these criteria, as these marks do not satisfy the criteria that has been discussed above. Going back to the PowerPoint that we PowerPoint presentation that we referred to. So when you look at the particular graphical representation criteria, as you can see under section 2(1)(k) of section 2 clause 1 subclause K of the Trademark Rules 2002, it essentially stated that graphical representation means the representation of a trademark for goods or services in paper form. So the Trademark Rules 2017 amended the definition into the fact that graphical representation means the representation of a trademark for goods or services represented or capable of being represented in paper form, and includes representation in digitized form as well. Now, in the case of Ralph Sickman versus Duce Patent and Marknant, this particular case is very important because it laid down the criteria for registration of a trademark, as in whether a particular mark is graphically represented or not. There was a criteria that was dealt with this within this particular case. So Ralph Sickman had filed a trademark application in Germany that claimed to register a smell mark that essentially was described as balsamically fruity with a hint of cinnamon. To meet the criteria of graphical representation, the applicant presented the smell by writing its chemical name, that is methyl cinnamate, and also the structured formula, that is C6H5CH CHCOOCH3. He submitted a container with the sample of the smell and also indicated the laboratories that he can provide the smell of the particular sample of the smell. So essentially these were the particular kind of representations that he had provided. He had written the chemical formula, the structural formula of the smell, and also a container which contained the sample of the smell at that point of time. Now, this application was rejected by the German Patent and Trademark Office and was ultimately decided on an appeal by ECJ, whereby they rejected the application on the ground that these criteria were not fulfilled over here, right? That the particular graphical representation was not clear, it was not precise, it was not self-contained, it was not accurate, it was not intelligible, neither was it durable, and nor was it objective. Because when referring to the particular chemical formula, it was not clear as to what that formula would intend to for any person. For example, for you and me, we will not be able to understand the smell of the mark until unless I have a specific idea of chemistry. I'll not be able to understand what essentially this formula would give rise into a smell. And this is neither precise, because to one person it might appear to be a different kind of a smell, and to the other it might appear to be a different one. It is not self-explanatory, it is not accurate, it is not intelligible until unless you have a specific idea of the chemical formula. It is neither durable, because when you provide that sample of the smell in a container, it might change with time. It could change with the amount of heat it is exposed to, with the different weather that it is exposed to. So it is not durable, and neither it is objective. It will change according to the way people understand that particular smell. So again, the Sigmund criteria was not justified by this particular uh, form. So as you can see, the ECJ, the European Court of Justice, opined that the trademark needs to be represented graphically and should also be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. The written description of the scent was extremely subjective, and it could be perceived and interpreted differently by different people. So that is why it was not essentially precise in nature. It was not objective in nature, right? It was subjective according to the person who would actually interpret that particular formula. The structural formula does not represent the smell, and it could not be readily understood by the consumer, right? You and me, any layman would not be able to understand the particular smell, would not be unable to understand the representation of the smell until and unless we consult a person with the knowledge of chemistry in the particular field. ECJ also opined that the structural formula does not meet the requirement of graphical representation, as any person looking at the register will have to consult another person with expertise or knowledge to understand the chemical structure. This placed an immense burden on a person who is referring to the trademark register. ECJ opined that submitting samples of the scent will not serve the purpose, as the smell is not durable. It was of the opinion that the smell can change depending upon its exposure to the local environment and is also likely to change over a period of time. So essentially that is one of the reasons why smell mark could not get the kind of protection that it was trying to achieve. So this is one of the instances where the odor marks could not get the protection. The other kind of non-conventional mark which suffer the defeat of not being capable of being registered are color marks. As you can see, color marks, for instance, are now accepted as marks since the 2002 amendment of the Act. In European Union law, colors and combination of color can be protected and registered as trademark. However, there were decisions, for example, Libertal versus Benelux Marking Bureau, where the ECJ pointed out that the consumers do not usually look at a color to distinguish a product. and that the color on its own is not capable of distinguishing a good as being of a particular undertaking. The court held that the trademark should not be duly restricting the availability of trademark, essentially, as only a limited number of colors are available. In the case of Colgate-Palmolive versus Patel, the Delhi High Court held that the word limitation in the section refers to the limitation to and not of that particular color. The court also observed that the color combination is a trademark as per the Act, as there is no exclusion per se, and even a single color is thus entitled to the protection of law. However, in Cipla versus MK Pharma, the court made a diametrically opposite observation that a single color or a color combination will not be able to qualify for a sufficient for an application. While the 2017 rules clearly accept color marks for registration, the position of the law is not clear due to varying judgments by different colors, and various inter-party disputes in this regard are yet to be tested. Another kind of non-conventional mark where the Indian courts or the Indian legal framework uh, are impacted by the fact that whether a particular non-conventional mark could be registered because it was being hit by the criteria of graphical representation is the sound mark. Sound mark uh, has been facing the issue owing to the fact that it cannot be essentially graphically represented that properly. So in the case of shield mark BV versus used kist, the ECJ, while interpreting Article 2 of the Trademark Directive, laid down that it must be interpreted to mean that sound can constitute as a trademark on the condition that they can be represented graphically. So that doesn't preclude sound mark per se. Now the point is that when you are trying to for example, if you're trying to write the notes of a particular sound, those notes can actually appear differently for different persons. So at a time when digital recognition was not there prior to 2017, right, when digitally the marks were not being able to be registered, as a similar case with regard to color marks as well. So for example, color could fade with time, so there was no criteria of durability. It would not be durable if today you put a color in the register in the physical application. That color would fade with time, so it would not be easy for a consumer or for any particular person to identify what color the application was essentially trying to have a trademark over. Similarly, in the case of sound mark as well, if you write the notes of a particular music of an MP3 file, it is not possible to understand what essentially the note is pertaining to. So it is also subjective in nature, because different person would have different understanding to it. It is a subjective criterion, and also any layman would not understand the notes, right? You would need a person skilled in that art to actually explain to you what that sound was like. Now, after the fact that we have introduced the digital version of application, it has eased the process, because with digital version you can actually save the note in the form of a MP3 music file, and that is why it could actually get the protection. In the case of shield mark BV versus used kits, the court laid down that a sign is represented by a stave divided into measures and showing in particular a clef, musical note, rest, whose form indicates the relative value and where necessary accidental. Sound marks have been routinely registered in several jurisdictions such as USA and Canada, where the sound is so inherently distinctive or that is readily recognizable. So talking about the Indian jurisdiction, when we talk about staves or musical notes, it's not easy to understand it like only on graphical representation. So until and unless there is an MP3 music format, it is very difficult to understand what you are trying to register. Now, in India, sound marks have been accepted because here it is not being made in musical notes, but also with musical notes we have the MP3 music format that you send to the registry for registration, And along with the musical notation on paper, it is also clearly audible using the MP3 music file. So India has more or less followed the stance, and it is now clearly being accepted under the Indian jurisdiction. Uh, Essentially, till now what we could understand is that slowly there is a particular stance with regard to the graphical representation, and the particular criteria is being relaxed slowly. India has made several accommodation for the graphical representation of non-conventional marks such as sound or color mark, but several inconsistencies remain to be resolved. As we saw that, in one case, we saw that the color marks received registration, but in another case it did not, right? In case of single color, as you can see over here, right? In Colgate Palmolive Co versus Patel, there was registration, but in Cipla we saw a different observation, whereby a single color or a color combination was not sufficient for an application. So these kind of issues have stayed in India for some time, and it is creating a problem with regard to registration of trademark. In the European Union, however, there are several amendments that have been seen, that have been brought to the European Union trademark regulation. It is pertinent to note that since these developments, India has actually imitated the position of EU law in certain respects, especially in registration of sound marks. And these might provide a way towards resolving the uncertainties in Indian law, especially in the registration of color and odor marks. Under the EU law, under Article 4 of the EU regulation, trademark regulation, European Union trademark regulation, Article 4 of it, which deals with signs of which an EU trademark may consist. It reads as that an EU trademark may consist of any sign in particular words, including personal name or designs, letters, numerals, colors, the shape of goods, or of the packaging of goods or sounds, provided that such signs are capable of distinguishing the particular services of one undertaking from those of others, and they are capable of being represented on the register of European Union trademark in a manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded to its proprietor. Now, these words, capable of being represented graphically, were removed completely from the article, thus removing graphical representation requirement of a trademark. Right? Graphical representation is not required. We need only a representation per se, in a precise and a clear manner. A reading of the article shows that the definition of trademark that effectively reduces the complications and have hitherto plagued non-conventional marks. The mark or the sign may consist simply of the requirements given, provided that they can be represented in the register so that the competent authority and the public can determine the subject matter. This in fact directly harks to the judgment in Swizzle-McLaw. So, to some extent, as far as Indian law is concerned, we have observed that there is no clarity on how graphical representation might work with odor or color marks. There is no clarity as to whether an odor mark might be registered under the trademark law and rules. In addition, there is an ambiguity due to the clashing case laws on whether a single color may be registered as a trademark and whether the color combination is to be seen in conjunction with the entire mark. So what we can understand is that there are certain difficulties that till today India is facing with regard to registrability of a trademark due to the requirement of graphical representation. While the United States requirements leave a lot to the discretion of registrar of trademark, the European Union regulation has simply loosened the requirement to an extent. By removing the requirement of graphical representation, the regulation significantly eases the filing for application, the applicant can submit anything that enables the competent authority to make the particular decision. Previously excluded marks such as color or taste mark might have taken the first step towards being registered as trademark in the European Union, as the biggest obstacle has now been comprehensively removed. With the advent of computerized registration of trademark, a lot more avenues have opened up for the recording of the marks. For example, colors are now being represented in HTML using hex codes that assign each exact shade with a 6-figure alphanumerical value that enables precise recognition of a color or a shade. Many companies, universities regularly use hex code color schemes, and filing of a trademark application has become easier due to this. With further technological developments, there may be more innovations which offer precise, unmistakable determination of odor marks by the authorities and the public. The removal of graphical representation requirement provides a clue as to what course may be taken with regard to the same in India. With technological advancements, sound marks have been accepted in MP3 format. It further technical advances can be accommodated in the Indian situation. There is an incentive to remove the graphical representation requirement. So it could be only representation, not necessarily graphical in nature. It could be technological representation as well, which is currently being introduced under the 2017 format. And this would actually talk about reducibility of the mark, like reducibility of the mark to be represented in paper, right? So with the technological advancements, this particular issue could be resolved completely. So here what we actually discussed in this particular video is essentially pertaining to the requirement of graphical representation. So along with the first requirement of distinctiveness, we also saw how under the Indian trademark law, the graphical representation requirement essentially entails how a particular trademark can be registered in India. Thank you.